Hi everyone, I'm Elizabeth Voss, Editor-in-Chief of Disobedient Media, and I am here once again to read you one of our articles, and it is titled, Lawyers for the DNC Argue That Primary Rigging is Protected by the First Amendment. And as you can guess, I and a lot of other Twitter users were not happy about this brief that was filed by DNC Defense Counsel. And I think that there is a lot that can be said in addition to what I wrote in this article that I'm considering writing another article on this brief that goes into more of a big picture discussion of why it's important, why and the other issues that it sort of relates to, whereas this article that I published yesterday was just an overview of the document itself and the immediate implications of the document with regards to this suit itself. But again, I think that the suit and this document are really important to understand in relation to the current hysteria about Russian hacking, collusion, Facebook trolling, clickbait farms, and whatever else it's going to be next. So, but that isn't something that I get into much in this article. So again, I may publish my thoughts on that in an op-ed at some point in the near future. But I just wanted to get that out of the way because I know that as I'm reading through this, there are a lot of comparisons that can be made between what is said in this statement and the ridiculous Russian hacking narrative. So I just wanted to state that, and now I'll get right into reading it for you. So the ongoing litigation of the DNC fraud lawsuit and the appeal regarding its dismissal took a stunning turn yesterday, which was a number of days ago at this point. The defendants in the case, including the DNC and former DNC chairwoman Debbie Wasserman Schultz, filed a response brief in the case that left many observers at a loss for words, myself included. The document, provided by the law offices of the attorneys for the plaintiffs in the case, Jared and Elizabeth Beck, appears to argue that the Democratic Party, if the Democratic Party did cheat Sanders in the 2016 presidential Democratic primary race, then that action was protected under the First Amendment. Twitter users were quick to respond to the brief, expressing outrage and disgust at the claims made by representatives of the DNC and Debbie Wasserman Schultz. And also, another thing this article, as written, did not get into is the ridiculousness of Debbie Wasserman Schultz and her appearances that she made with Evan Ross a number of times. You know, there are a lot of things that you could talk about just stemming from this article, but again, I may get into that at a later date. But the defense counsel also argued that because of Jared Beck's outspoken Twitter posts, the plaintiffs were using the litigation process for political purposes. Quote, for example, plaintiffs counsel Jared Beck repeatedly refers to the DNC as shitbags on Twitter and uses other degrading language in reference to the defendants. That's the end of the quote. But fascinatingly, no mention is made regarding the importance of the First Amendment at this point in the document. The defense counsel also took issue with Jared Beck for what they termed as, quote, repeatedly promoting patently false and deeply offensive conspiracy theories about the deaths of former DNC staffer and plaintiff's process server in an attempt to bolster attention for this lawsuit. And there are a number of reasons to get really angry about that specific quote. First of all, they don't even mention Seth Rich or Sean Lucas by name. And second of all, the attention given to the DNC fraud lawsuit is virtually nil. So the idea that there's too much attention on this case is ridiculous. It's absurd. The DNC fraud lawsuit gets almost no press coverage whatsoever, while we watch this whole Russian collusion and Russian hysteria unfold day after day after day in legacy press. So the level of hypocrisy in this statement is so mind-boggling and unbelievable. It's difficult to know where to start in talking about it. But continuing on with the article as it's written, this author was shocked to find that despite the characterization of the Becks as peddlers of conspiracy theory, the defense counsel failed to mention the motion for protection filed by the Becks earlier in the litigation process. They also failed to note the voice-modulated phone calls received by the law offices of the Becks, which contained a caller ID that corresponded to the law offices of Debbie Wasserman Schultz, who was a defendant in the case, a singular defendant. In light of this context, the Becks hardly appear to be peddlers of conspiracy theory. The DNC defense lawyers then argued that there is no legitimate basis for the litigation, calling it an improper attempt to forge the federal courts into a political weapon to be used by individuals who are unhappy with how a political party selected its candidate in a presidential campaign. And that, again, is absolutely mind-boggling in the sense that it could be applied to Robert Mueller and this entire Russian hysteria. but it doesn't seem to have any relationship to the DNC fraud lawsuit, at least in my mind. The brief continued, quote, to recognize any of the causes of action that plaintiffs allege based on their animating theory would run directly contrary to the long-standing Supreme Court precedent, recognizing the central and critical First Amendment rights enjoyed by political parties, especially when it comes to selecting parties' nominee for public office. And although I am not a legal mind at all, I think that it's absolutely horrendous that they are citing the First Amendment in defending their cheating of Bernie Sanders from the nomination, and that they then turn around and also say that the Jared Beck's Twitter posts are somehow out of line while using the First Amendment to defend themselves. Absolutely unbelievable. It appears that the defendants in the DNC fraud lawsuit are attempting to argue that cheating a candidate in the primary process is protected under the First Amendment. And if all that weren't enough, the DNC representatives also argued that the Democratic National Committee had no established fiduciary duty to the plaintiffs or the classes of donors and registered voters that they sought to represent. So that seems to mean that the DNC is arguing for its right to appoint candidates at its own discretion, while simultaneously denying any fiduciary duty to represent the voters who donated to the Democratic Party under the belief that the DNC would act impartially towards the candidates involved. Adding to the latest news regarding the DNC fraud lawsuit was the recent finding by the UK Supreme Court, which stated that WikiLeaks cables were admissible as evidence in legal proceedings. If WikiLeaks publications of the DNC emails are found to be similarly admissible in a United States court of law, then the contents of the leaked emails could be used to argue that, contrary to the defendant's latest brief, the DNC did in fact favor Hillary Clinton over Senator Sanders, and they actively worked to sabotage Sanders' campaign. The outcome of the appeal of the DNC fraud lawsuit remains to be seen. Disobedient Media will continue to report on this story as it unfolds. And that is the end of the article, but if I can find the correct page, I would like to read to you one of the really appalling statements that is in this document that I didn't quote in that article. One of the statements reads, even if the plaintiffs could articulate an injury traceable to defendant's conduct, a federal court could not remedy that injury without impermissibly infringing the defendant's First Amendment rights to free speech and association by injecting itself into factional disputes within a political party. That is on page 10 of the DNC response brief, and I will link directly to that in the description of this video. But what I really want to point out there and highlight is where they say, even if plaintiffs could articulate an injury traceable to defendant's conduct. Because what that means is, that's them, as far as the way that I'm understanding this, and if somebody has a refined legal understanding of this issue, please correct me if I'm wrong here, but it sounds to me like what they are saying is, even if the plaintiffs could articulate an injury, i.e., even if the plaintiffs could prove that we rigged this primary election, a federal court could not remedy the injury, etc., because it's protected by the First Amendment. So that truly boils down to them saying, even if you could prove that we rigged this primary race, you can't do anything about it because First Amendment. So I'd really like to hear anybody else's thoughts on that. And if you all read the document yourselves, tell me what you think about it. And, share this around. I really, the DNC fraud lawsuit does not get enough attention. It doesn't get enough publicity. And the Becks have gone through hell and back in fighting this case and appealing the earlier dismissal, even despite all of the threats that they have received. And even when Bernie Sanders himself seems to have, abandoned the movement that he began and is towing the line on this ridiculous Russian hacking narrative drama that we've seen unfold recently after the indictment that Mueller, where Mueller cited Russian clickbait farms as somehow trying to interfere with the election. So without getting into all of that right now, I just want to say thank you for watching. Thank you for listening. I'm really happy to see what you guys have to say about this issue. And you can find me on Twitter at Elizabeth Leavos. You can find Disobedient Media on Twitter at Disobedient News. You can find us on Facebook, although if you're still on Facebook, I would really, really suggest that you go to Steam it and make an account. It's a much better platform, and you can find my work there. You can find Adam Carter's work there, and soon you'll be able to find Kenneth Whittle's work there. And that's all I have to say for today, guys. Thank you so much. I really appreciate it. I'll see you next time.